Hello, my name is Bill Haley for Haley 2024 The Movements Government Reform Ideas. This is a second video. We're splitting this video up to two sections because it became too long. We should stop the funding of programs and setting policy by lawsuit settlements through the Judiciary Department. It needs to go through the Legislative Department. We have a lot of categories we're going to go through. The first two categories were concentrating on big banks with mortgages and the like, and big tobacco with the lawsuit settlement creating hundreds of billions of dollars over many years to collect money and then do programs for stopping smoking and the like. And even at that, it was problematic. So this problem should receive a lot more study than I can do myself. It's a huge problem and it needs a lot more study and solution and focus on this. Congress or the state legislators, they create the law. It's the only place that money should be coming in from when they create the taxes, and then the only place we should do spending is when the legislative branch approves and goes through the normal process of legislation to spend money and to set policy. So all government spending should go through legislation. All government regulations and laws should go through legislation, not through the settlements. So too often the courts are allowing spending and policy to come through lawsuit settlements. And I think we need to put a stop to that and move towards going back to legislation, the proper role of the three branches of government. The executive usually happily signs off if they like what they want certain things done, but they can't get it through legislation. They happily sign off on the lawsuit settlement with policies that they like. So sometimes they even invite or they promote the lawsuit, or the attorney general through the executive department. They do the lawsuit themselves. These are spending or policies they cannot get through legislative branch. And again, that's iffy. There's a lot of issues out there. Some things they can't, some things they can. But every issue is a little bit differently on that. So that's partially true there. These are spending and policies. Okay, I already did that one. Okay, this blog was created in 2017. I'm updating a little bit. There's a video is in 2023. So a lot of these stories are 2012, 2013, 2014, and the like. That's separate, but it's very relevant and even more relevant now. Separate video concentrates on banks and tobacco. Those were the two mains. I'll touch on those a little bit here. But if you want to go deeper into those two subjects, that the other video is about 28 minutes, I think it is. This video will touch on many more subjects. Suing big banks. So an advocacy group or the executive department through the, in this one particular case we looked at was the attorneys general of the states, sued big banks claiming regarding mortgages. Hundreds of billions of dollars are awarded. That acts as a tax because the only place that money can come from is the big banks charging, let's say 3.5% versus 3% on a mortgage. That's more money. That's money coming right from the consumer, the borrower's hands, paying those payments. So instead of your mortgage being $2,000, it's $2,200. The extra $200 goes towards paying this. And it's very, very similar to a tax. And when it's on all the banks or the very heavy majority of the banks, it acts like a tax. Policy is part of the settlement, so you'll see a lot of policy built into this. Now the other video goes more in depth to some of those policies. So here's the Department of Justice website. The link's on my website. You can find the blog pretty easily under my blog page, and then go down to the title of this blog. But this is a $25 billion agreement. And it gave homeowners relief, but guess what? The only place the banks get the money to give this relief to the homeowners is by charging the homeowners. The exact same homeowners that they're giving relief to they had to tax. They had to collect that money. They had to get that 3.5% versus that 3% interest rate. The extra $200, if you will, for that mortgage per month, that's going to pay for this. So it acts like a tax. There's policy involved in it, and then a big one was bribing states. To do this, we're going to give the states money. We're going to give the states money directly. So that is bribing the states. If the states don't take it, it still happens, but they just lose out. Their people in their states still have to pay that quote unquote tax, that extra interest rate to make up that money. So in a big way, the federal government's forcing the states to do bad policy. Fortune.com and MarketWatch articles state that the money went to homeless shelters, horse stables, mental health programs, pension plans, and over $1 billion cannot be tracked. We're just talking abuse, and these are government spending type of things, even though that shouldn't be government spending. And but that's a big subject on its own. But mental health programs, why should banks be paying for that? Pension plans, why should banks be paying for that? Okay, a full video was on that. Big drug. We see the same when it comes to drug companies. The government bureaucrats knows that they can extract any concession when pharmaceutical companies from pharmaceutical companies when they hold the keys to the FDA approval. The number of FDA rules are very concerning. Some are vague and others contradictory. This is the lawsuit haven. So there's a lot there. It's hard to get down deep into that, or this video is just hours and not hours long. When tens or hundreds of millions of dollars are at stake, concessions and settlements are easily extracted. So, hey, give $10 million to this program that I love, and you get the FDA approval. Yeah, that stuff happens. The drug companies end up voluntarily funding programs outside of government, and that was air quotes voluntarily, funding programs outside the government that the executive bureaucrats wanted but could not get through Congress or the state legislative branch. So where did the money in the big tobacco go? Here's NPR articles from 2013. This is $246 billion. So over 25 years, that's $10 billion a year. And that's a lot of money that acts like a tax. The only place these drug companies, tobacco companies get the money. They didn't have that $246 billion. Over the years, they would have to collect that money in the sale of every pack of cigarettes, which means that acts like a tax. It did not go through the legislative branch. It went through a lawsuit settlement. The Judiciary Department and executive cannot implement a tax, but they did. This is like government spending. Voters decided. So voters decided where the money went to? How is that even right? Yeah, voters should decide where proper tax money goes to. In a form of government that we currently have, I go to a little bit different form of government. Look at my website. But voters decided where big tobacco monies went to? How is that even right? And a lot of this did not go towards healthcare or taking care of tobacco-related diseases. So it went to different pension plans and the like. Voting laws. Let's just go to different aspects. In 2020, with COVID hit, the state legislative branch is where election law is set. Who gets to vote, when they get to vote, and how that voting happens. That did not happen here. The Constitution puts the legislative branch in charge of voting law. Well, people sued the executive, the registrar's offices and the state secretary of states came to a lawsuit agreement, a settlement agreement that was not the same as legislation. So they did wrong. Even the Supreme Court said they did wrong, but it was after the fact, no way of correcting the situation. Many lawsuits and settlements create actual policy versus legislation. So that is just so important to understand, that happened and it continues to happen, and we need to have a stronger push back against it. Extended time, signature verifications, rule for mail-in, many aspects of voting law was changed by lawsuit settlement, not by legislation. The Supreme Court stated it was unconstitutional, but it was after the damage was done, and there's no fixes. You can't just throw everybody out of office. The previous people were already out of office. You can't just put somebody else back into office because they didn't actually win, and then you don't have a legislative branch to do anything. There's very big problems with this. Marriage law. So, all legislative power, this is the Constitution here, Article 1, all legislative power herein granted shall be vested in the Congress of the United States. I want to do a key word, all legislative power. This is not Article 3. Article 3 is the the judicial powers. So I can't say the word now. The judicial powers. All legislative power belongs in the Congress. Not any belongs in the Supreme Court. But what did the Supreme Court do in Obergefell, the gay marriage law? They made law. They made law. There's no law in Virginia. Let's go specifically for Virginia. The Constitution set marriage, the Constitution of Virginia set marriage as a union between a man and a woman. That is state law. There is no law that says two people from the same sex can get married in Virginia. There is no law stating that, yet it is happening. Regardless of whether you think of that policy or not, it is not law because the Supreme Court cannot make law, cannot make federal law, and especially cannot make state law. Now, can they, if they declare it unconstitutional, void a law? Maybe. I don't think it applies in this case, but let's say they can void a law, then we have no marriage law in Virginia. So we have no marriage law in Virginia, but they didn't exactly say that, so we still have a marriage law in Virginia, but they cannot add the words, and two people from the same sex can get married. They're not allowed to add language to the law. Anyway, and there is a non-separation clause. You cannot just separate this law by saying that part that says two people from the same sex cannot get married. You cannot just take that out. It's non-severable. It's non-severable. It's in the Constitution as non-severable. Plus, the Constitution did not list what can't happen. It lists what is a marriage, not what is not a marriage. Okay. Obergefell gay marriage is creating law. The Supreme Court did not just say what cannot be done. It created law. Roe versus Wade. Now, you can just, I understand the nuances here, but it created abortion law in a very big way. You can claim that it just limited state government's ability to do certain things that they declared unconstitutional. But when they start doing trimesters and they really start getting down deep into the weeds, they created law. And that needed to be in the legislative branch. It's not right. Regardless of whether you think abortion should be legal or not legal, at least with the current case in 2022, it took Roe versus Wade, got rid of it, and now it's back to the legislative branch. So some states have it more legal, some have a lot more restrictions on it. So that part was corrected to some degree, even though, anyway, we won't go farther into that one. Monopoly law. So big companies are often targeted by big government and to get them to do certain policies or fund certain programs that they want funded or operate their business the way the bureaucrats or the politicians want. So price gouging, predatory pricing, and collusion is these are all three laws. One's pricing too high, one's pricing too low, and one's pricing just with everybody else. They can get you whatever your price is, they can get you on that. And they can put you through a lawsuit costing tens, if not hundreds of millions of dollars. And so people know that. The business owners and the lawyers know that. So they'll give in and give $10 million to a program that the politicians want funded. There is common argument that the law, well, I'm not going to go through that. You can pause and read that if you want. So they give in to the politicians' demand just to get rid of a lawsuit that's costing too much. Microsoft went through that, and I won't go further into that. Let's just keep on going, or the video is going to be way too long. The cost of lawsuit is in the hundreds of millions of dollars oftentimes for big, huge companies, especially when they're being sued by many, many attorneys generals across the states. Concessions are made just to get rid of the lawsuits. Often the judgment is very high, and the court-appointed master over the settlement states that if the company funds an outside group, they will count the funding as double. So let's say they have to pay a $10 million penalty. Hey, if you give $5 million to this partisan group over here to advocate for this one area that might be somewhat related, I'll count that as $10 million instead of $5 million. Oh, no problem. Then I'll love to fund, or say $5 million on that. However, now they're funding a partisan group. And sometimes it doesn't have to be partisan, but it is government spending at that point. It acts as government spending because you are forcing through lawsuits a big company. A big company is kind of like a tax. You tax Walmart, you tax Microsoft, you're taxing everybody in America because everybody in America goes to Walmart or buys a Microsoft product, or a high enough percentage that it's everybody. And if you don't, the people that they do business with, they buy it. It all incorporates in. It acts like a tax. Okay, I'm not going to go into this. I pretty much talked about that. You can stop and read if you wish. Discrimination law. Banks were forced by regulators and the Justice Department to do predatory lending. And the way that happened is they say that you're not spending enough money or giving enough loans to, or doing a lot of things with minority lenders, or minority borrowers. So you're not funding enough, redlining and the like. So you're not funding the minority people. Well, to do that, they have to lower the standards. When you lower the standards are there to protect the bank and the consumer and the borrower. When you lower those standards, you lower the protection for the borrower. Many black people in this country, statistically, have been harmed dramatically by having significantly lower standards for borrowing from a bank, because the banks needed to get their numbers up, statistically their numbers up for minority borrowers. And they were willing to take the loss from those minority people, because you get bigger losses with lower standards. You lower the standards, you get bigger losses. That's just the way the game works. Not black people in general, you get lower standards. No, they lowered the standards for black people to get those numbers up. And thus it harmed the black people statistically. That's one of the reasons they have a net worth significantly lower than the white population. They were denied branches, mergers, and other necessary business practices until they had higher lending to the black population. That happened big time in the 1990s. It happened all the time, but I can remember instances in the 1990s where they really talked about, you get your numbers up or we won't let you do normal banking practices. And thus, the banks had to predatory lend. And it harmed the people they did predatory lend to. They had to lower the standards for black population. I already kind of went through that. I'm not going to go through it again. If the average black family has a dramatically different net worth, which they do statistically, lower income statistically, and credit history statistically, they will have different lending rates, but the judges, the lawsuits and everything, all they do is say the lending rates are different from black to white. Therefore, they're guilty of racism and discrimination. Well, not necessarily. They didn't look at the right standards and the right issues. Is if the lawsuit should be, did they use the same standard for black population and white population, not whether the rates are the same? Because regardless of the reasons why, black families have statistically lower net worth, income, credit history, and the like. Okay, so many other areas of discrimination law, not just that, but many areas of discrimination law, employment discrimination laws and the like, really cause a lot of problems because it's giving black people they're accepting lower standards, whether it's police or people into many different areas. You get a lower standard because they have to lower the standard for educational rates or SATs, or they have to lower, whether it's colleges or whatever, they have to lower their standards to get the black population's rate up. Therefore, the black population does worse in those jobs because they came in with lower standards compared to the average, statistically. Some of these settlements have millions going to groups specifically for helping the poor. So a lot of these settlements said pay money to a group, that these groups are specifically to help minority borrowers or minority to get a job or minorities to do this or that. Horrible policy, horrible results. We see the results, but they think that they're doing good. It's doing a lot of harm. But these are lawsuit generated money coming in. It acts like a tax, spending like a tax, and spending like government spending, but it did not go through the legislative branch. But regardless of whether it's going through legislation or whether it's going through lawsuit, policies are normally really bad and doing a tremendous amount of harm. Civil asset forfeiture. A lot to say on this, but many police stations have a percentage of their budget paid for by civil asset forfeiture, which means a police officer takes money or property away from somebody they suspect is doing a criminal activity, but no charges were actually done for that person, but they keep the money, and that money funds the police officers. It's theft. They know it's theft, but they say it's better to have police officer even with stolen money. But it's very dishonest tax. It is a tax. It's very dishonest, very horrible type of tax, but it is like a tax, and it is going to pay for government services. It's like government spending. It's paying for police officers. We need police officers, but when the police officers act as thieves, we go into a very bad way. So we should not be doing civil asset forfeiture. It goes a little bit different. I mean, a little bit off topic on this whole blog, but in a very big way. The money's not coming in from taxes to pay for police officers. So it's very relevant there. It's very problematic, and there's a lot better videos from civil rights groups out there that deals with that. Google civil asset forfeiture and who's fighting against it, and you'll be surprised at just how evil that is. Okay, this creates a situation that the policeman's job is threatened if they don't steal from the citizens to fund their paychecks. Yes, civil asset forfeiture is theft. I don't have time right now to get into it, but go into that. You can Google it. You'll find a lot of articles. I know the organization is off the top of my mind. I just can't get it out right now. What that organization is that fights against it, but they have some awesome videos. And it's very disturbing videos. They try to justify it by claiming at least they have police, because otherwise they wouldn't have police, but they become the thief. Okay, healthcare laws. Healthcare laws was created by King v. Burwell. This is the Obamacare case that went up to the Supreme Court. couple years after the Obamacare was passed. It was dealing with state exchanges on whether the federal government can fund state exchanges or do something with state exchanges or something dealing with that. However, it created law. It actually changed the letter of the law, even though Obamacare was overwhelmingly broad, overwhelmingly vague. It was made for lawsuit haven. It was made for a lawsuit haven, and bureaucrats to do what they want to do. Very discriminatory, they can call it discernment if they want to, but a lot of cases discriminatory and subjective, and just it creates a bad situation. But that Obamacare, Affordable Health Care Act, it's lawsuit settlement haven, and it goes into a very bad way. One of the 1,000 lawsuits that changed what the law stated to the judge or executive, or to what the judge or the executive wanted. So even if it wasn't passed, now don't get me wrong, the legislators, the actual congressmen, had no idea what was in it. Listen to Nancy Pelosi, she states that we don't even know what's in it. We had to pass it to find out what's in it. So we have a bad system in the legislative branch, but at least it went through the legislative branch. Constitutionally, they're not allowed to do what they did. However, at least it went through the legislative branch. But now it just gets to be played with by the bureaucrats. Anyway, but that's one of thousands. In the Affordable Health Care Law, Affordable Health Care Act, ACA is Affordable Health Care Act, I believe it is, in 2010 was made to be worked out by the courts and by bureaucratic decision. Okay, let's go to EPA, one of my last ones here, I think. Many environmental related lawsuits create policies and regulations. So EPA is just a general clean up the environment type of law that created that. It wasn't highly specific and allowed too many, just like the ACA, it allowed, it was a lawsuit haven. It allowed the bureaucrats to make way too many decisions and be subjective, use their subjective determination, which is bad for law. It's great for other things in the free market, but it's very bad for law because people don't know what the law is. And it created many lawsuits, and it forced many policies and regulations through the courts. That's where a big part of, I forget what it's called, but it gives the executive and the bureaucrats say on what the law is, if it's reasonable. And it's not a good system. The legislation really needs to spill out a lot more of what the law is. That's why we shouldn't have big, huge pieces of law, because the legislative branch, the actual congressmen, do not understand what they're even voting on. So often these very vague environmental laws open up the EPA bureaucrats to do what they wish to do. Often the EPA bureaucrats invite lawsuits from interest groups and settle on what the bureaucrats wanted to do, but could not make it through legislation. Or they sue directly to a landowner doing what they want to do, and very, very subjectively, very unconstitutionally, very dishonestly puts in or states something that they did that either they didn't do, they didn't prove they did, or hey, that's not been in the law and that's not normal practice. We should be allowed to farm or do what we want to do with our land. Many lawsuits have settlements directing the defendant to fund projects desired by the EPA. So the EPA wants a lot of things funded. They can't get it through legislation, so they'll sue people. They know they sue people with deep pockets, big companies and corporations. They sue those big corporations. The big corporation knows the lawsuit is going to cost tens of millions of dollars in lawyer fees alone. They can cause a lot of problems in a lot of their areas because it's a big corporation, so they own a lot of land. So they put a big lawsuit out on them and say, hey, this lawsuit will go away if you fund $10 million to this wetland plan. So it's open for abuse and corruption. And that's why I go to a competitive regulatory agency for environmental law in my reforms. Look at my website for the whole reforms, and it really stops the corruption. It stops the a lot of these problems. Or to have policy that was never passed in legislation. So many things are not passed in legislation. They are created either by the bureaucrat or by lawsuit settlement. So it's policy and funding of programs. So big corporation doing tens of billions of dollars in business, they get a lawsuit and the bureaucrat says, hey, pay 10, 20 billion dollars, $10 or $20 million for this, what we want funded. Okay, I guess I have to play ball. Or to have policy that was never passed by legislation. I already did that. The three branches of government need to stay in their lane. So I'm finishing up here, 31, probably 32 minutes by the time I finish. They need to stay in their lane. Legislative branch needs to legislate. Executive department needs to actually execute what the legislative branch does. And then the judicial needs to be a legitimate judicial department. So they should not be able to do lawsuit settlements where they're funding programs, when they're making policy. If an interest group or bureaucracy cannot get what they want through legislation, they should not be able to go to the court, or intimidation with very high cost of litigation. So again, about 32-minute video. Everything's easier to find on Haley2024.org. Please consider a donation, and then really look at the reforms I have with competitive governance. So this is one of the big problems with the current system. So I just wanted to bring that to everybody's attention. And until the next video.